Mediation Station, and this is your host, Greg Fenton. Each week we'll explore topics and ideas related to the experience of people with conflict and look to promote the profession of conflict resolvers. We are available to connect with at fentonmediation@gmail.com and at 647-227-4734. Visit us at our Facebook page to like us and Facebook group page to become a member. Also visit the YouTube channel called Fenton Mediation. Listen to podcasts of Mediation Station on SoundCloud, Apple Podcasts, and on Google Podcasts. Please follow us at our Twitter account at Fenton Mediation. The conversation today is titled Divorce Act. Trying to play catch up to mediation. And with me tonight are Laura Tarcea and Eva DiGiammarino. I got that better this time.
That was great.
And we're going to continue to present the program live each Sunday night from 8 to 9 p.m., which is the usual routine if we were at the radio station. And we'll do it through Zoom because there can be no live in-person programming at the station because of COVID. We will engage in conversation with everyone attending, able to listen and watch. Microphones and webcams will be closed. If anyone wants to contribute, there are two options. One is to see the chat icon as a bubble at the bottom center of your screen for you to click to then type in a comment or question and click to send. Or you can click on the reactions icon that is also on the bottom center of your screen for us to see. We will acknowledge you to open up your mic and you can speak to share verbally, and then we'll close your mic. The show is being recorded for both video and audio purposes and will be available for public access on SoundCloud, Apple Podcasts, and Google Podcasts afterwards. Let's see. So I have a little article I wanted to share before we got into the meat of our conversation tonight. This is from April 7th, 2021, and it's written by a person named Eric Dolan from Cognitive Science, Relationships and Sexual Health. It's called New Study Sheds Light on Neural Representations of Romantic Love and the Impact of Conflict Mediation. New research provides evidence that third-party mediation improves the outcome of difficult conversations or discussions between romantic partners. The study, published in the journal Cortex, also suggests that interpersonal conflict can alter how the brain responds to the perception of one's partner. For the study, the researchers recruited 36 heterosexual couples from the general community. Prior to the experiment, the participants completed measures of the quality of their relationship, intrapersonal and interpersonal emotional competence, and other factors. The initial survey also included ratings of the level of disagreement on 15 recurring topics of conversation, such as finances and household chores. The couples were asked to start a discussion about one of these areas of disagreement. The session was accompanied by a professional mediator who helped to direct the conversation for half of the couples. For the other half, the mediator was present but did not become involved in the conversation. The researchers found that active mediation was associated with improved satisfaction about the conflict discussion and whether or not an agreement was reached by the end of the session. Conflict is a normal and impactful experience that we all have to live through, and there are ways of going about it that are less destructive, more constructive than others. One of these ways is using a third-party mediator, which won't necessarily take away the negative emotions associated with interpersonal conflict, but it may increase post-conflict feelings of satisfaction and contentment. These positive emotions are incredibly important for the long-term health of our relationships. Before and after the conflict discussion, the researchers used functional magnetic resonance, MRI, imaging to record the participants' brain activity as they viewed images of their romantic partner's face or images of an unknown person. The imaging data provided evidence that the conflict discussion altered the neural representation of romantic partners. The activation before the conflict replicated earlier studies on romantic love, showing an activation pattern in brain regions such as the particular cortex areas of the brain. And after the dispute, we quite logically observed a general deactivation in both groups in the regions associated with romantic love, including the striatum. Last paragraph here. When comparing couples who received active mediation with those who did not, the researchers found that the former tended to have greater activation in the nucleus accumbens after the conflict, which is a key region in the brain's reward circuit. However, this trend did not reach statistical significance, possibly due to our sample size. So basically, they're saying that there needs to be more study. So how do you think this might relate to creating co-parenting work amongst the two of you guys?
Co-parenting work?
Yeah.
So between me and Eva, would Eva and I co-parent?
No, your efforts as family mediators working together to assist adults from intimate relationships that's transitioning. They have children, and so your plan is to create a substantive, meaningful, productive co-parenting relationship.
It sounds like a quiz test, like a question for a pop quiz. I wasn't ready for the pop quiz.
I know. You see?
That means that I should have listened to the whole article when you read it.
I can see you used your active listening skills.
It is.
So,
it is absolutely essential to and we do see the power of mediation and a third-party mediator when we do discuss this kind of issues with parents, and especially reframing and rephrasing, especially hearing it from someone else from a neutral stance has been extremely powerful. And an example just came to mind when you were speaking. Because I was listening actually.
Oh,
an example just came to mind because we had a family where the father had mentioned he was very upset about the child support, and we recalculated child support. We had a whole conversation about it. There have been numerous arguments between him and his former spouse over the years over child support, and he felt patently punished by the system. That, you know, it's always, every time he says, every time I get an increase, you know, I get penalized by increasing the child support payment. So
he took it personally, and not about the best interest of his children.
Yes, yeah. And it was very difficult to have that. It was very difficult to have, you know, to try and not only acknowledge the fact that he was feeling exactly what you were saying. You can't remove the feelings and the emotions, the negative emotions that exist through mediation, but you can help them see it a little bit differently. So I did acknowledge what I did anyway in that, you know, in that moment. I did acknowledge the frustration. So I did validate his point that it must be very, very frustrating and upsetting. However, instead of penalizing, you know, I rephrased that, and I said, every time you get an increase rather than penalized, your children are getting rewarded. So it really shifted not only the way that he immediately took that in, but also the way that he's now former spouse was dealing with this issue at the table, right? So it was just that quick shift that immediately had him relook at this and realize that, yes, the kids are the most important to me. And yes, I am happy that they are actually, you know, benefiting from this increase. So that's my opening opening statement.
Do you have a perspective on this, Eva?
It's funny. I was thinking about the exact same example Laura was, so that I'm glad she brought it up, because that was a very fundamental moment in one of our co-mediations where the parties' perspective switched. But I think where I wasn't surprised at the statistics you presented in the article about whether the mediator was present or not. And how that had an effect on conflict, because one of the criticisms that I think we're all very familiar with about our court system is that it often pits parents against each other. So it puts parents in a win-lose mode, right, where one person has to almost prove why they're the better parent to get whatever they want, or some type of a benefit in family court, and then we expect them to co-parent in a healthy way without providing them the resources, right? Instead, mediation takes the opposite approach. We start, often Laura and I do at least, when we're working with co-parents, we start from a place of, okay, you're still a family, you're still a team, you're going to look a little different, even if you may not feel that way. The very thing you can do, or one of the most powerful things you can do, is present that to your children. How can we start from that place and then start prepping for, what the details of your co-parenting plan look like? And so that's, I think, what stuck out for me.
Yeah. So, I mean, that's the power of the skill sets that we need to incorporate in our mindsets when we're actively involved in a process.
Yeah.
Is to be connected to people, to what's said, to what's not said, to then see how we can interject to help support. So the reframing is a powerful tool that you can take, quote, what's expressed negatively and present it in a positive or more neutral manner that takes out that judgment. And, I think a continuum through the process is to inject positivity. So let's segue into our focus for tonight, which is Divorce Act, trying to play catch up to mediation with Laura and Eva. And so how about each of you, how are you guys connected? Let's start there.
Well, I think you were the initial connector.
Oh, Laura, I was going to say drugs and alcohol, but sure, Greg.
So that was easy.
Who supplied who?
Whom?
Okay, we're on the PG. We're the PG version of tonight.
Yes.
Yeah, well, we can always edit something out. Though for the viewers in here, they'll have to experience it live.
That's right. That's right. So the truth is, yes, Greg introduced us. So Greg is the glue for this wonderful partnership that Laura and I have.
You have a connection. You're from different paths, different streams, and obviously you hit it off and you established a strong relationship, and you do co-mediation work in family matters, right?
That's, yeah, perfectly said. Yeah, Laura and I work. We have our individual mediation businesses, but we often work in tandem practicing co-mediation. So when we're working with a family that is going through separation and divorce, we find that the best way to provide them with a holistic service is for us to both be at the table together. So my background is in legal, and I'll let Laura explain her various background in mental health and telling it like it is as well. And so, yeah, that's where we kind of come from.
Well, my background is in mental health and some community work. Well, a lot of community work, really. I finished last year or the year before, I'm not sure. Just finished a master's of laws in dispute resolution. Where I've been working for quite some time now in a co-mediation model with Eva. Sometimes we work also with Marty Klein. So I do believe verily in the co-mediation model, just for many reasons that we can have a whole show about. So. And it does come from the community, and I know that Greg, I think that's the smile that I'm seeing there, is that yes, community wins again. The model that has been established by the community in the community does win, because it does provide, to Eva's point, a holistic approach. And it provides a lot more security and different views at the table that can enhance a process and can help parties move through the transition in a much more effective manner.
Yeah, because community mediation is based on co-mediation model. That's my background, community mediation up in Jane and Finch. And that's where I connected with my passion and my purpose and what I do and how I do what I do. So what do you guys see as your intention when working with parents whose relationship as intimates has ended?
Well, we intend to come out of it alive. That's
what do you mean? What do you mean by that? Please.
We intend to come out of it unscathed. What can be often a very high conflict or emotional conflict about it. I say that in jest. I think Laura and I'll speak for Laura, but I think we're pretty aligned in that we approach every family with the honor and respect that we would give our own family members if they were going through a separation and divorce. It never we never lose the sight that going through a separation and divorce is extremely emotionally taxing, financially a big burden for a lot of people. It's a new transition that often one person, at least, if not both, both people don't want to be there. Right? Don't want to be in that transition, don't want to be in mediation. And so we approach it really with the perspective that if we can help families get through this in a healthy way, we're providing a service that not only benefits the parties, but also the family unit as a whole. Laura, anything to add on that?
That's very well put. We do actually care. So, one thing that we really haven't lost, and oftentimes we hear from professionals in the field that, there's an element of becoming jaded, or, another family, another number type of thing. One thing that we haven't lost, and I feel very truly connected with Eva and with Marty when we do the mediation, is we haven't lost the care. There's a lot of care, there's a lot of commitment, and we know we go above and beyond to help them support, just like we would go for our own families. So that in itself, helps us get to a different degree of help and support. So even if the scope of a mediation is a particular specific scope, we do sometimes, we ask for permission, of course, but we do sometimes go outside of that in terms of, engaging resources, engaging supports that they may need, because mediation in itself, it's not an end all be all. There's a lot more things and resources and supports that families do need during the process and after, post separation and post mediation. So we sort of become the whole holding hand for not just during the mediation, but after the mediation as well. And we check in sometimes and we make sure that, families are still on the right track. And we sometimes have to say, we are very scared to check in. So we don't check in for some of the families because we feel lucky. We got them to a point, and we quickly change our emails. So that's just the reality of some families we work with. It's, some deal with conflict differently than others, and we have to mold. That's all we can do.
So on one level, on a practical level, all that you say makes sense. I mean, mediation is a process to help people to help themselves, basically, from my point of view.
Absolutely.
And so, a situation where the relationship is ended as intimates, it comes with it with a lot of lived experiences to that point.
Mhm.
It could be the most traumatic experience for people to end that relationship.
Mhm.
They may have gone through a whole series of situations that involve domestic abuse, violence, intimate partner violence. How do you get people to be receptive to your message?
Yeah, it's not easy. What comes to mind is often we have families who are at different stages of what we call the grieving process. So, oftentimes we'll have one partner to a romantic relationship who has already grieved the relationship. They're ready to start on, they're ready to get a new partner. They've spent months, if not years, planning this transition, getting emotionally ready, financially ready. And then the other partner, for whatever reason, is saying, well, I'm hearing that you're unhappy for the first time. I didn't get a chance to work on this. I don't want to be here. I don't have closure. And so often Laura and I are trying to provide an environment where the partner who is ready for the transition can focus on the logistics of the next step. But we have to make room, if the other partner is comfortable, to talk about some of the emotional foundation that's led the couple to that place. So we don't push our clients to speak about the emotional issues in mediation if they don't want to, but we certainly, at the very least, promote both partners having emotional support as they go through this process, whether that's through a network of friends and family. We always promote counseling as well, and therapy. If someone needs a little bit more legal advice or financial advice as well to feel more secure. So I think that's one of the starting points in terms of some of the different emotional places that some of the clients can be in.
And depends on so we always start the mediation with what's called a screening for domestic violence and power imbalances. So we meet with parties, parents individually before we meet with them together. So in that meeting, we have a comprehensive, it's confidential, so we have a comprehensive discussion and sort of an assessment of where they're at in terms of their emotional needs, in terms of the relationship dynamic, in terms of their perspective of the relationship dynamic, because we do have families who sometimes feel that there has been an ongoing pattern of abuse, financial, physical, emotional, whatnot, and we have another partner of the same family, believe it or not, that has no idea and no understanding, or does not perceive the same level, if there was a level of abuse or degree or anything like that. So we do have two different stories all the time. And we have to somehow connect those two different stories and refocus those different stories on the post-separation process, on the children, on the needs of their co-parenting relationship moving forward. So there is a lot of risk assessment, and there's a lot of reshifting. And Eva and I have to debrief after all of this intakes, so initial meetings, to make sure we prep accordingly, given what's come out, what's transpired from that one-on-one, and how to prep, especially if there has been any pattern of abuse or domestic violence or intimate partner violence. We do deal with that as well. We don't throw them to the curb, that's Eva's saying, and I'm going to say it myself. We don't kick them to the curb and say, well, there's elements of abuse in this relationship, or we screen you out of this process.
And then you automatically run to the other side, right? No.
Right. The intention is to still help these families move through, because they have chosen to be at this table. They have chosen to try, even despite their history of violence or whatever the case may be, they have chosen to try and transition in the most healthy way through this process. So we have a duty to help them as best as we can, obviously, with the adequate and appropriate resources, because lots of times we may not be qualified nor equipped to deal with the underlying severe trauma that might have a family might experience, but we are qualified to engage other professionals in the process to help them through, to help us as co-mediators, and to help the family move through at a healthy, lessening the risk of conflict and escalation of conflict. So there are ways to deal with that. And you can tell I'm getting a little bit faster in my speech, is because this is where my passion is going. And I have been advocating on multiple platforms, and I have been very vocal surrounding, family mediation where domestic violence and intimate partner violence has been present, that I am not sure that screening these families out of mediation and placing them, therefore, in a court system, in an adversarial system, is the healthiest way to deal with it. So I will take a breather.
Hear you. Yeah, take a pause, take a swallow there. I had a program, a show focused on this, screening in or screening out, a few years ago, and I'm adverse to the word screening anyways, because it's about filtering in some way, and I'm not about filtering. It's about assessing in some way, see where people are at, to then see where people could be best directed to or guided toward.
Yep.
And so the overall skill set that I hear from all of you is about adaptability from my point of view. Being able to connect in the moments as they happen, and then knowing yourselves that you've got an inventory of tools within your toolbox. You can pull it off the shelf and apply it, incorporate it for this family in relation to these individuals who are comprised of the co-parents, because as you said, they're individuals. And so they're not going to be at the same place emotionally, mentally, lived experience and perspective. One's usually taken the first step to end the relationship, and the other one's like caught off guard maybe, or a variable range of different factors as part of that. So getting people to stay out of court is really my drive, to never go into court, though of course being mindful and recognizing there are certain situations that are best served for the particular needs of the family if they do go through court, though that's the exception rather than the default for me.
Right.
So federal and provincial laws pertaining to the family were recently changed March 1st, 2021. Prior to that, the changes, how has the family justice system approached things with people who make an application into the system? So we're looking at the period before March 1st, so we then can get into unpacking what's happened since. What was it like before?
Sure. So I can speak to a little bit of what it was like before. For a very short period of time, I took some litigation cases under the older legislation. So I used to represent individuals in family court. Not much has changed, and I think we'll get to that topic in a bit. I'll be completely honest. The same structure of win-lose is still there. The same application and response, and the way the court processes information is still there. What has changed as of March 1st, probably one of the more fundamental changes, although in my opinion I don't think it's been much, but one of the more fundamental changes from what we used to see prior to March 1st and what we see now is there has been a language shift. So what we used to refer to as custody, access, they're very hot button terms, and rightfully so, because they are relics of a high conflict cases, right? When people come to us, they say, oh my God, custody, who has custody? What do we do about custody? How do I access my child? And what we've noticed is those terms have tended to increase conflict without meaning to do so. So the terms have changed. So now we refer to parenting time and decision making instead of custody and access, which is what those terms had referred to before. At least that's one major change.
Yeah, and the identification from my experience with custody for people is that it's control and ownership.
Yep.
And, especially custody of the child. I own the child. I can do what I want with the child.
Completely. Absolutely. And there's also a lot of confusion and there's some confusion and blending of the two terms, and that's not the fault of every any Joe or Jane off the street. It's because in a lot of our media and legal shows and movies, those concepts are already conflated. So often people think of custody is how much time I spend with a child, but that's not actually the case. Custody has nothing to do with how much time you spend with the child. You can have sole custody and see your child one day a year or never. Custody, which is now referred to as decision making, is exactly that. It just refers to who makes the major decisions in the child's life. So the terminology, I think, has become a little bit more readable and more focused on getting the layperson to understand.
If I may, on that topic, the terminology is very important and has created a lot of arguments and alienation, really, between the parents and who has what and ownership. Also, now it does focus on parenting and parenting responsibility and decision making, which I think it's good. But I also think that is 30 years late. So it's, we have been using this terminology in mediation forever, because mediation has always been a child focus, family focus process. So given that was by default the terminology that has been used since. So to us, to see that in the new bill, it's great, but it is just playing catch up. So that's my first catch up of the evening.
Well, let's put context to that, though. Because the bill, the law, the statute change, Divorce Act, etc., and then the provincial laws that correspond with that, I should say. The terminology, that's part of the system's approach to dealing with families. It's not, quote, broader societies, though the system has become the de facto area that people think they need to go into to get the decisions about their family when they transition. And so you're referencing, Laura, about these terms that have been long in mediation. I'd say external from the system. In the family court system, family mediation there is using that same terminology up until recently, unfortunately. So it's just to give context that out in the community, there is a difference, and you and I believe Eva would be all aligned in this whole sense of promoting that people are best off to deal with things on their own, independent of the court as much as possible, to have ownership of their decision making that can be customized for their individual needs and interests of the family, and navigate from that. And I remember too, I had another show with Michael Cantor, who used to be the Ontario Attorney General's mediator over 311 Jarvis for a number of years before he retired. And it was talking about changing the terminology. Like, let's get up to date here, because words matter.
Mm-hmm.
People get meaning from the use of the particular words. You guys?
Absolutely. And what Laura and I have seen even recently with families, just because legislation changes doesn't mean it changes on the ground. right? That still needs to take effect. And so, recently we had an individual in mediation who was very concerned with obtaining custody. And that person was convoluting custody as it was almost like that person was treating custody as a tangible asset to put in their pocket, as opposed to what we were trying to explain is, no, it's decision making, it's contextual, it comes up as the child grows, and it's not something to put on a shelf, right? It comes, here and there, and is usually done in conjunction with your co-parent, right? And so, but it was the preoccupation with the word as an item to win that we had to work with that person to kind of move through.
And to unpack that, the win is what? It's not to win the children per se, it's to win
Right.
against the other parent.
Right. Or to have something over the other parent.
Right, yeah.
Yeah.
Something tangible and concrete.
Right.
Laura?
And I mean, we can go back to the some of the changes that have been instilled. So another one is the encouragement of lawyers to tell their clients about mediation. So that again, I don't want to be the only person here who's doing the catch-up talk, but that again has been something that research has shown. Research has consistently shown over, with absolutely without a shred of a doubt, that mediation is much more beneficial than litigation, and yet. So research should have been the driving force anyway, because that is what's in the best interest of the family to begin with. So that should have been at the core. And I know for some collaborative lawyers or for lawyers who are engaging in collaborative approaches, they do, and they have been doing this for, forever. They have been engaging and encouraging their clients to go to mediation before going into litigation. However, now the new changes have made this a little bit more clear as a requirement of a legal counsel to direct their families to mediation.
Isn't it so as well with the new act that if there's a file, that the lawyer on record has to sign something that says they've attested that they've informed their client of this encouragement to avail themselves of the option as well?
Yeah. But see, and then that brings us back to how you're delivering that information.
Right.
So how are you informing? Is there a particular script? Is there a unified script? Is there a unified message that is being sent to or delivered to the families, or is it through their own vernacular? Because words have meaning, and the way that that information is delivered to whom, it makes a great deal of difference. Because we've had families, and we can share emails. I can share a screen with emails where we have families who had messaged us and said, my lawyer informed me that mediation is a waste of time. So that lawyer can technically sign that he or she has informed their client about mediation. However, it's a waste of time. They also informed that it's a waste of time. So we have this is the disconnect that we have. This is the unfortunate, a really unfortunate disconnect, because we could potentially work together for the family's interests. However, we're not. We seem to be pulling apart rather than working together. So that's the information piece there. So yes, you can sign it, but are you also signing what you've said and how you said it? So.
Well, Eva, you mentioned too that with the changes, it's one level, and on the ground is another level. Yeah. Does it go into play? Does it go is one thing, and then how is it, with going back to what Laura's just said, how it's presented can make the difference on how people react or respond to that, positively or negatively.
That's right. I think because Laura and I are often working with, everyday people going through separation and divorce, we see pretty regularly the disconnect between the court system and the legislation and the people on the ground. In my experience, most people still think that the court system is the first place to go if you have a separation and divorce. And in fact, if that's not the case, the legislation says itself, it should be the place of last resort. But people don't know that. And then just like, Laura suggested, or I think she suggested at least, it really depends on the professional that you meet when you start the process, right? Like many other areas in someone's life, when someone is vulnerable, they can fall into or they can be privy to the feelings of whoever is guiding them, right? They can feel that, or they can take on some of the opinions of the people they trust around them. And if the people that are guiding you and advising you are saying the only route for you is court, right, and really not providing the information to to suggest or to empower the person to solve their conflict outside of court, then they're going to just lead that way, right? And the reality is we have professionals in Ontario, legal professionals in Ontario, who do not believe that court should be the place of last resort, right? So that there's the disconnect on two levels, right? The legal professionals and on the ground.
So I want to take this moment, if anyone in the audience there wants to send a chat or open up their mic and share their comment or question, we'll engage with that and incorporate that as part of the conversation. You're welcome to do so throughout. I have another article within the Law Times, and it was on April 7th, 2021. And there's a comment within. Basically, it's about Divorce Act changes a boon for collaborative law practices, family lawyers. Collaborative law, let's see. And I think that's going to be a boon for family lawyers who practice collaborative practice. They're trained to resolve matters outside of court. They agree not to go to court as part of the participation agreement when they do things collaboratively. So I think collaborative lawyers are really set up well to adapt to the new changes. Further, collaborative law is an alternative dispute resolution process, which involves a lawyer for each party who has special training in interest-based negotiation. The practice is suited to matters where there is a power imbalance between parties and lawyers are nervous sending their client to mediation. What is your response to that last statement?
My favorite.
What does that mean?
My favorite statement. So first and foremost, going to mediation does not mean you are unprotected. Doesn't mean that you cannot have legal advice and a lawyer representing your needs or your whatever in mediation. It means the opposite. You are much more protected if you go to mediation because it is, first of all, is a confidential process, and there is the ownership remains and decision-making remains with the parents in a family context, meaning. And if there is a vulnerability that has been even assessed by us in the initial assessment interview with the clients, or has been assessed by their particular, their respective counsel, then counsel can be present in the mediation or throughout the mediation, however the client feels it needs to be. So I disagree so much with that statement because it's kind of a horseshit information. to provide
How do you
to
really feel about it,
families,
please?
to provide to families, it is absolutely something that it's a demonstration of why our families are afraid to engage in mediation and try to resolve their matters outside of the court, and the information, how that information is presented to families. Because on the other hand, collaborative lawyers, maybe perhaps in that sentence, they should also say that if the families do engage in collaborative law practice model, and that collaborative process fails and parents do not get to an agreement, then they would have to start from scratch with a new lawyer, and this collaborative lawyer can no longer represent them and support them through. So it's I'm not sure if that information is delivered in the same sentence, because if it is, then at the very least, the same, I mean, that family can make an informed decision on both grounds. But needless to say, I do feel that mediation can be structured much more strictly in order to protect families moving forward, rather than, other processes out there.
Well, I would say with the word protect, it's not even that. It's better to support the family from my perspective
Sure.
in their going through their lived experiences, including the struggles they go with and through after transitioning to become separates, independent of each other. So they have to create a construct that works for the benefit of their family, unique to another family.
Mhm.
You want to add anything, Eva, to this
Sure,
point?
I'll add to that unfortunately that statement in the article neglects to consider that collaborative lawyering, just like lawyer-led negotiation, is expensive. Most collaborative lawyers charge a minimum of $250 an hour, and most of them, it's very common for them to ask for a retainer of $1,500 to $5,000. Often individual who has it's lawyer-led negotiation, it's just a different style of negotiating, which I think can work for a lot of families if you have practitioners who are good at it, but it's not affordable for the majority of families out there. And so often that's why a lot of families do turn to mediation, because it can be much more cost effective. And I do agree with Laura that there is a myth among the legal community, not among many of them, but among some of them, we've seen it with our own eyes, that recommending mediation could not be in your client's best interests, or it could be scary, or there could be a fear associated with it. And it's frustrating as practitioners, because if those lawyers would reach out and talk to us about the process, they would see that this can be a very safe space and actually bolster the lawyer and their responsibilities, because we're there to empower the team, right? Surrounding the party, not pitting them or taking them away from their legal representatives. So I certainly hear what Laura's saying, and I would just add that piece about the affordability.
In addition, from my perspective, with the context of the promotion of the imbalance aspect, and that by having a lawyer present automatically balances things, is not really understanding a deeper context of the imbalance that may be from the lived experiences of domestic violence and related matters. And that family mediators are accredited, and as part of that accreditation process, they have domestic violence, intimate partner contests as part of that. Somebody wants to contribute from the crowd there. You got to raise your hand there, mister. Comment. This is Mr. MK. Do you want to open up his mic?
Sure.
Or you want to type it in? It's up to you. You have two options.
So the mic doesn't work really well. Maybe you want to type.
You want to type your comment in the chat and then just click send, and we'll air it in public here and we'll discuss it. Mr. MK? Okay.
Okay.
I was just saying that mediators, family mediators are trained in the whole essence of power imbalances controls relative to, I'm not sure how much training lawyers get as part of that dynamic. It's required in family mediation. It may be an option in family law. I don't know. You would know better than me, Eva. Okay, all right. So let's, until we get on the duties of lawyers. Well,
Yeah, no, I can speak to it if you like, or was there more of a...
Yeah, you want to, do you see the comment in the chat there? It says, want to comment on the duties of lawyers. I cannot type it too much.
Oh, sure, sure. So yeah, so we can speak to a little bit more. I mean, let's be honest. The duty of on lawyers is not much. Lawyers have been lawyers have been signing divorce applications. So on a divorce application, if you are going to get a divorce in Ontario, it already asks lawyers to confirm that they've explained, alternative dispute resolution to their clients. But to Laura's earlier point, it's a self-reporting process, right? So, technically a lawyer can advise that, hey, mediation's not going to work. Okay, I advised you, right? I would prefer that, if, for example, there could be other ways in which we can inform the public where it doesn't necessarily have to come from lawyers. So, for example, if you're applying for a marriage license, or if you're, buying a house with your partner, or if you're opening a joint bank account with your partner. Those are other ways that we can get maybe the information about alternative dispute resolution from the community without individuals who may actually be benefiting from a system that is not alternative dispute resolution.
I remember in my earlier days from community mediation that developed a project of co-parenting with another organization downtown in Toronto, and it was funded through Trillium, and it predates where the download from the Attorney General in 2011 across the board with all the family courts with mediation and information resource sharing. And it was about bringing that in the community, not the court, so that it was more powerful for people in the community, from the community, to be able to address their concerns and issues and their tensions in their family dynamics with kids, or parenting issues or property in that domain.
Mm-hmm.
So these concepts, these ideas have been out there. It's just that there seems to be this struggle within the system that the system needs to continue to be the de facto or default for family and decision making, where I believe Laura and Eva, you both promote about the shift actually needing to be the emphasis in the community.
Absolutely.
Every family who's benefiting from a healthy process is benefiting the community at large. It's going to impact the functionality of the household, that neighborhood, that community, and that's why it's important to look at the family as the core of the community. And if the family is the core of the community, then the resources and the supports have to start there and meet them where they're at, whether they are going through a separation, or whether they're going through an illness, whether they're going through, housing issues. All of this should be addressed and approached at that level. So mediation was it was one of the changes that, you know, we are still playing catch up on. Another change, because I know I'm looking at the time and we can talk about this for forever. One of the other changes that has passed is they have the definition of violence and the abuse has been expanded upon. In the context of family, you know, the primary consideration is safety, security, and well-being of the child, physically and emotionally and psychologically. So there is an acknowledgement that obviously, and this is an acknowledgement that has been in the research again for IONS, that families who are experiencing domestic violence and children who are witnessing domestic violence are more prone to obviously post-traumatic stress disorder, depression, behavioral, you know, negative behavioral impact, and psychological, financial issues in the future. So that is something that has been expanded upon, and the act, you know, highlights the family violence against a child or another parent is relevant to the children's best interests when assessing parenting responsibility and parenting time with a parent.
And they include with the violence aspect too, the acknowledgement about abuse to animals.
Mm-hmm.
So that link of how individuals treat animals is directly linked with how people treat humans.
Mm-hmm.
And so these are warning signs, red flags that are part of the domestic violence, intimate partner violence whole mindset,
Mm-hmm.
though they still believe that animals are property overall.
Right.
Which is
Yep.
not a sentient being. Yeah.
And there's also emphasis on the fact that the domestic violence or the violence at issue does not have to have a criminal record, which is a big one for lawyers, because oftentimes the way to substantiate domestic violence or domestic violence accusation was to say, well, where's the police reports, right?
Mm-hmm.
Where was the medical reports? And the reality is, for many survivors of domestic violence, especially now in COVID, it's really difficult to obtain that type of evidence. It's often that survivors don't reach out for help in those ways. And so now there is an acknowledgement that you don't have to have that history of what we would call evidence to back up a claim of domestic violence. So hopefully that will ease some of the burden of proof.
Still to be determined, of course, for sure.
Of course.
Yeah.
Of course.
So how do you see trying to get within the system? We have a question.
Yeah.
A hand raised. Just let me throw this out there and then we can shift to Stephanie with her hand up. How do you see the system trying to not just keep playing catch up, to actually be somewhat proactive? Yeah.
Laura?
Well, I think that's a very tough question, and you know, we have been advocating for community supports all along, and resources. You know, every single time there is a crisis, there is a family justice system crisis, we see legal professionals asking for more funds, for federal government to allocate more funds to the legal system, to the lawyers, to legal aid, to all of that stuff. Yet we don't see any funds or requests to be allocating these funds into building adequate community resources based on the information and the research that we have at hand, including the family violence, including the way and the manner in which people reach out in order to ask for support, including safety, right? Because court is not safe, including, confidentiality, all of the child abuse, witnessing, all of this information we have and has been provided by research has been ignored and is trivialized, actually, if we narrow our requests to give us more money for legal professionals and for the system. because that's not what the families need. The family need support on the ground level. They need information at the ground level, and they need safe spaces in which they can address all of this nuances and elements that they're experiencing during the divorce and separation and before divorce and separation, because we have tons of research that is showing that before separation and immediately after separation, the risk of intimate partner violence increases by 7-fold. So including homicide, suicide. So that information is critical. And that information is not going to be respected if we're just going to pump more money into the legal system, because all of these happen at the ground, in your neighborhood.
Yeah. So I remember too, with community-based where I was, we created a project on parenting skills. So that's for individuals who are going to be parents, new parents, to be able to get equipped with a course, I think 6 or 8 weeks, that would provide them with insight and skill development from a mindset and practical component. How do you raise a healthy child, basically? So can you open up Stephanie's mic?
Sure, of course. Okay, so we have a comment or feedback.
Hello, thank you. Thank you so much, all three of you, for being here. So kind of to go back to a couple of points you've made earlier. Hi, Greg. I just would like to ask if you could expand a little bit more, especially for those who are listening who may have not gone through a mediation process or who are thinking about the mediation process. If you could expand a little bit on how mediation is able to maintain that safe container of emotion for families or for the parties, while still being able to hold task and maintain focus. You've talked a little bit about it throughout, but I'm just wondering if you could expand on that a little bit more.
Sure. Did you want to start, Eva, or do you want me to start?
I can make a quick point, and then I'm sure you can add to it. As a good partner always does. Often we get families who are afraid to come to mediation because they're afraid of the conflict, right? And what we tell people is that's okay. It's okay to be afraid of conflict. A lot of people aren't crazy enough to put themselves in the middle of it, like Laura and I are. And then, especially when it's about your kids and your family, your finances, your romantic relationships, there's a lot of different areas that we're touching on, very personal things. And so I think one of the first places for me, at least when I hear the question is, we try to first set an environment where we show our clients through our actions, but also by telling them at the outset, they're safe. What we are there for primarily is to manage the conflict, right? That's what Laura and I are there for, or the mediator is there for, to help manage the conflict so that it's okay to be angry, to be hurt, to have those emotions of betrayal, fear, anxiety. It's okay to express them. What we try to do is to give people the space to do that in a healthy and safe way. So there's a lot of different ways that we can go through that, whether it's, structuring the mediation in a different way or focusing on certain topics over others or reframing things in a certain way. So I think a lot of that work really comes from setting the environment, providing education on what the role of the mediator is, and then backing it up with actions and checking in with our clients or parties in a general mediation process to see how are you feeling supported, can we do anything else? And Laura, I don't know if you have anything to add to it, but that's where I was kind of took the point.
And that's always, thank you, Eva, and that's always the starting point. If we assess, because this is why we are doing the assessment, the initial assessment with each party individually, and each party has a story, and that sometimes is very different than the other, and where there are elements of domestic violence and power imbalances, we structure the mediation in a way that not only promotes the safety, but also manages some of the conflict and escalation, such as we request before entering mediation that each party or each parent have legal advice. Another way is that each parent or one of the parents do attend in conjunction with the mediation some form of a therapy, and have some kind of a therapy mechanism integrated as we move through, and we check in with that external professional, of course, with the permission of the parents. So even before we enter the joint mediation, we structured the mediation in a way that makes sense to everybody and keeps everybody safe and includes the resources that need to be included. Sometimes we have to include the voice of a child report. So it takes the heat off of the parents, where we no longer hear the voice of a child, because it is a child focused process. When we no longer can, or we have never been able to hear the voice of a child in that, back and forth between the parents, we would include a professional who does a report, voice of a child report, or does a custody assessment, provides the recommendations based on, where the family is at and based on the difficulties they're encountering. Other ways that we can also structure the mediation, and when we had an office, and I don't know when we'll ever be in person again and put actual pens on, we also have shuttle mediation. So rather than having parents in the same room, we would move back and forth. We stagger when they come in and they go out, so they don't see each other sometimes, because even an eye roll or a shrug of a shoulder can trigger certain behaviors that are not necessarily, positively contributing to the discussions and to what we're trying to achieve. So we find out the elements and we manage those elements through whatever exists out there. This is what I was saying in the beginning, that we do go, Eva and I do go above and beyond in involving as much as we can in terms of extra hands where needed and however those are needed, including sometimes we have to have financial forensic analysts, financial people, planners, so that, if there is any financial control, or one party does not fully understand, financial has never been, their strong suit, which is absolutely fine, then we have an educative component integrated in it as well. So that person, gets to the level of the other person and feels that they can negotiate at the same level, level playing field. So those are some of the elements that we can integrate in mediation. And then sometimes, and I know that Marty and I did a show the other day, sometimes we would actually engage in what's called mediation arbitration. So instead of the parents entering pure mediation, they would enter mediation arbitration that has a sort of an extra piece, an extra phase at the end of the mediation. If mediation fails, then they move directly to arbitration, and there is some kind of finality there, because the arbitrator will make a decision that it is binding on both parties, and do take into account all of the elements that may be unhealthy elements contributing to the dynamic, and the post-separation, of course. So in a very, very, very long-winded way, does that kind of answer the question, Stephanie? Did we mute Stephanie?
Her mic's, she's muted again, so
I hope he answers.
Chat,
he answers some of the question. There's definitely, mediation can be very creative in addressing this type of elements. Whereas, unfortunately, just because of the way that court is structured, it cannot. So that's where I find there's a lot of power in mitigating and making sure that certain elements can be managed properly and healthy.
And that's one of the other realities of the system, is that it's very structured, formal, it's restrictive, it's constrictive, and there's much more flexibility and latitude to adapt external from the system in the community, and it's based that approach. So Stephanie responded very thorough. Thank you. And also one other point, just before that, you brought it up again, reinforced it, Laura, here, which we had talked about at the earlier point. So an iPhone person in the crowd, just how about getting other professionals outside the legal system with expertise in intimate partner violence to support the parties, to help with assessment, offer suggestions to support. Yeah, it's all about connecting in a holistic way throughout as a continuum, right from the get-go to the end point when we end up not being involved in some way that parties transition on, to provide supports and assistance throughout. So we're almost at the point of saying good night. What do
It
you,
goes so fast.
yeah, there's another thing here. Good approach. The beauty of your approach is that you have a lawyer and mental health professional that can think about all these aspects, intimate situations. Do you guys ever need mediation amongst the two of you? Just
All the time.
All the time.
We never see eye to eye.
You know what? We escalate and de-escalate differently. So it's kind of nice. Laura escalates differently than I escalate conflict, and she de-escalates differently than I de-escalate. So we always find a happy medium.
Well, and this is what we say to parents all the time, that part of our co-mediation model is that one of the perks they will be getting is that we will be modeling the conflict resolution for them because of the differences in our views about a particular issue. And lots of times parents do witness us working through of an issue and coming to a resolution that meets both of our needs. And so it's it's an extra perk there that a co-mediation model can offer.
Absolutely.
Oh yeah, I mean, I had a show a few years ago too about the antagonistic mediator. If you show antagonism to a client, is that more likely to provide that they will say, let's agree and leave the process? So if you guys are sorry, go ahead.
I'm sorry. I was going to say, not that either one of us is antagonistic, but there's often one co-mediator or one of us who just jives with another party, and maybe the other one isn't jiving or isn't seeing their perspective or different, communication or cultural expectations or, and so that's why, sometimes Laura and I, we always debrief after every session, and I'll say, well, I really understood that point, and Laura said, that person's lying, what are you talking about? Yeah. So that's the nice thing about having two people at the tables. It's two people and 8 perspectives.
Yeah,
I
totally concur and understand the whole value of co-mediation.
Yeah.
Anybody from the crowd want to do anything before we say goodnight?
We're just going to we're just going to say goodnight and thank you all for participating. We'll be here next week, and have a really wonderful evening. Feel free to join us and contribute however you see fit at any time, but till then, have a really good night. Eva, thank you for showing up tonight.
Thank you for having me.
I was wondering. And Greg, thank you for showing up as well. I was also wondering.
You were wondering?
Whether
and just to ask you, what would you have done if I wasn't here?
It would have been a much more fun show.
Much more friendlier and informative, for sure.
Absolutely.
Thank you, Eva.
Thank you so much.
You put up with the banter. I don't know.
I love it.
All right. Good night, everyone.
Okay. Good night, everyone.
See you next week.
See you next week. Yes.
Good night.